We're going to be talking a little bit about the Corporate Transparency Act, and we have my associate, Brandon Rickwood, here. Brandon, why don't you introduce yourself as well?
Thanks, Wright. Hi, everybody. My name is Brandon Rickwood. I'm an associate here at Dunlap Bennett Ludwig. My primary focus is general corporate law, transactional law, and government contracting. I am primarily focused in Delaware. However, I'm also barred in Maryland and Florida as well.
Awesome. Thank you, guys. To start us off, I would like to ask you Brandon, just for a quick definition of the Corporate Transparency Act.
Sure, Kara. So the Corporate Transparency Act, it was passed in 2021. It requires private companies to disclose their beneficial owners, which we will get into shortly. It requires the disclosure of the beneficial owners to the Department of Treasury's Financial Crimes Enforcement Network. The acronym is FinCEN. So, Kara, there are over 33 million small businesses in the United States, and nearly 2 million corporations, limited liability companies, and other businesses are formed nationwide each year. So really, the Corporate Transparency Act will affect many of the businesses nationwide.
That's a lot of businesses. Could you tell us a little bit about why this law was created?
Sure. So there's the anonymous ownership of business entities. It could help criminals hide their involvement with crimes like terrorism, money laundering, tax evasion. So the purpose of this was for really the lawmakers were concerned that the lack of beneficial ownership information makes it more difficult for law enforcement to investigate and prosecute these crimes. So it was passed to address the information gap and provide transparency in business ownership to the law enforcement.
Okay. Right. Would you mind telling us what companies have to report this information under the CTA?
Yeah, absolutely. So, not everybody is subject to the CTA, only reporting companies. And the CTA defines a reporting company as any corporation, a limited liability company, or other legal entity that is formed under U.S. law, and any foreign legal entity registered to conduct business in the U.S., in each case by filing a document with the state or tribal government office. If there was any document filed with any state or tribal government to form the entity that you have, then that is going to be considered a reporting company, and only reporting companies are required to make a filing to FinCEN.
Okay. So what type of entities are exempt under the CTA?
Yeah, so there are some exemptions laid out in CTA. Really, there's 23 types of exempt entities, and these fall into four main categories. The first being large operating companies. This is going to be companies with 20 or more full-time U.S.-based employees, a distinct physical U.S. office, and a tax return for the prior year that demonstrates 5 million in sales or gross receipts. And it's all three of those. If your company is missing one of those, then you would not be considered a large operating company under the CTA and would therefore not be exempt under that exception. One thing to note is that the requirement of a distinct physical U.S. office, it doesn't have to be an office that your entity owns, but it does have to be distinct from other entities. So, like a WeWork space is not considered a distinct physical U.S. office under CTA. There are a couple other exceptions that may apply to a lot of businesses that are the size that our clients are. That includes a category that I call entities that are subject to significant U.S. government regulation. So that's going to be companies like, obviously public companies, banks, credit unions, and similar financial institutions, public accounting firms, investment advisors, and venture capital funds, and certain tax-exempt entities like your 501c3 type entities. Because those entities already have significant compliance and filing requirements with the federal government, they're going to be exempt under CTA. And then there's two other categories. Subsidiaries of certain entities that are exempt under the CTA. So if if there's an entity that's a subsidiary of one of those large operating companies that we talked about, or a subsidiary of another entity that's exempt under CTA, like a public company, those would also be exempt. And then finally, we have inactive entities. FinCEN and Congress isn't worried about if your entity hasn't transacted any business in a while. So like if you created an LLC in 1998 to do something with the Millennium Bug, and you never did anything with it, that you're not going to have to file anything there. So more specifically, inactive entity is an entity that existed before 2020. Is not actively engaged in any business, isn't owned by any foreign person, hasn't had any change of ownership or transacted sent or received any funds in excess of $1,000 in the last year, and doesn't hold any assets. So if you fall into any of those four categories, you would be exempt from filing, even if you are a reporting company.
Okay. So Brandon, what information about the company needs to be reported to FinCEN?
So, Kara, the information for the company is the full legal name of the company, as well as any DBAs or trade names. Also required is the address of the business. It's the principal place of business in the United States, the jurisdiction of the formation. So Delaware, Virginia, wherever it was originally formed, or registration if it's a foreign entity. And lastly, the taxpayer identification number.
All right, so there's also some information about individuals that need to be reported as well, correct?
That's correct. So for each beneficial owner and company applicant, the reporting company is required to report the names, date of birth, address, unique ID number, and also upload a valid form of ID, the image, so either a driver's license or passport. And that unique ID number would be your passport number or like your driver's license number.
What is a company applicant?
So a company applicant is the individual who directly files the document that creates or registers the company that's the reporting company. So that would be like a paralegal or attorney. And if one or more person is involved in the filing, the individual who is primarily responsible for directing or controlling the filing would be a company applicant. Only reporting companies created on or after January 1 are required to report your company applicants, though.
So that seems like it only applies to new entities.
That's correct.
Great. Right. What is a beneficial owner?
Yeah, so this is really, gets to the crux of what Congress was trying to determine here with the CTA. They want to know who the beneficial owners are of these entities, and so they define this pretty broadly. So a beneficial owner is any individual who directly or indirectly owns or controls at least 25% of all of the ownership interests of the reporting company, or anyone who exercises substantial control over the reporting company. So there's two possible ways there of being considered a beneficial owner. So we'll start first with the ownership test, and we have to kind of determine what is ownership. Obviously, if you own 25% or more of the stock in a corporation or membership interest in an LLC, that's pretty clear that you're a beneficial owner. There are other less clear situations. A lot of our clients will have various types of convertible securities like safes or convertible notes that are outstanding. You have to take those into consideration. Also, things like options. So if your corporation has issued options, maybe even to or warrants like to an investor or something like that, you have to combine all of that individual's holdings as if they had been exercised to determine whether or not they meet that 25% threshold for beneficial ownership. And then, aside from that, there's a catch-all here that says basically ownership includes any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership. So, if you have any way of showing that you own 25% or more, you're considered an owner. And then, also it's important to note that the ownership interest could be directly or indirectly owned, as well. So, we've got to look at this, as broadly as possible. And then even if you don't own 25% or more of the entity, there's also a second test, which is the control test. So somebody who doesn't own 25% or more could still exercise substantial control over the entity and therefore be considered a beneficial owner of that entity. Some examples of that are, the president, CEO, CFO, any kind of, chief operating officer, or even general counsel. They're all considered senior officers, and anyone like that or that performs a similar function would be considered a beneficial owner. Some other examples of indirect ownership that involves substantial control would be, for example, board representation. So, a lot of our clients who raise money from venture capital funds, the venture capital fund will have the right to appoint a member of the board. And so even if that fund only owned, 5-10% of the client, the fact that they have the right to appoint a member of the board means they are a beneficial owner because by virtue of their substantial control. Then there's a couple other ones as well. Various rights that might be associated with a financing arrangement could result in substantial control. Arrangements, or financial or business relationships where other individuals or entities act as a nominee on behalf of someone else could mean that the ultimate, the person on whose behalf they're acting could be considered a beneficial owner. And again, we have that same catch-all here with the control test as we did with the ownership test, which is again, any other contract, arrangement, understanding, relationship, or otherwise, which would result in substantial control, could result in that person being considered a beneficial owner as well.
So who would not be considered a beneficial owner?
Yeah, so the Treasury Department did carve out a few situations where somebody who would otherwise be a beneficial owner would still not, would not be required to report. For example, minors. So if a person that's a minor is an owner of a company, then provided that their parent or legal guardian is reported as a beneficial owner, we wouldn't be reporting the minor's name and information to FinCEN. Also, as sort of previously mentioned, individuals who are acting as nominees or intermediaries, custodians, or other types of agents, those would not be considered beneficial owners. It would be the ultimate person that they're acting on whose behalf they're acting, as well as employees of a reporting company. So long as they're acting solely as an employee and their substantial control isn't derived from any kind of other type of ownership interest, it's solely because they're in a major part of the business, but they're not a senior officer, that person also would not be a beneficial owner. Individuals whose only interest in the reporting company is a future interest through like inheritance, that would not be considered a beneficial owner. That's a future interest, not a present interest. And then creditors are not considered beneficial owners, even if they may have some future potential interest in the event of a default or something like that.
Okay, so pivoting now to when you need to get this information into FinCEN. Brandon, when are the deadlines for reporting?
So Kara, these deadlines are really important to note. So any business entity that was formed prior to January 1 of 2024, they have until January 1 of 2025 to file the beneficial ownership information report. If the entity was formed in 2024, they're obligated to file the beneficial ownership information report within 90 days from the date of formation. And then moving forward in 2025, any business entity that's formed will have to file the beneficial ownership information report within 30 days from the date of formation. So that's it's pretty critical that while it's on your mind to just go. And other deadlines really. So when if you have to amend your report, you need to do that within 30 days to file that report with it to make any changes. Really, some examples for reasons for an amendment really would include if there's a new individual that acquires 25% or more interest in the company. If a beneficial owner dies or sells equity, resulting in them if there's any change to the beneficial owner's address, if there is a new CEO or other senior officer that is appointed, you'll need to file that amendment as well. If there is a minor child that has an interest in the company and they reach the age of majority, that would also trigger an amendment. And previously exempt companies that no longer qualify for an exemption. So if there's, let's just say if there's a company that had 22 employees and they fall below 20 employees, or they fall below the $5 million threshold for that year, that would also, and so the big thing is what will happen if they fail to report. Can you hear me right? Is my signal?
Your signal's a little bit slow. Would you like to switch to your backup?
Yep.
All right. Got a backup plan in place, don't worry.
So I apologize, everyone. So what could happen if you fail to report the information or you fail to file that beneficial ownership information report? The penalties for failure to report could be $500 a day at a maximum of 10,000, and then there's also could be a maximum of 2 years in prison for failure to file that report. Certain penalties that may be triggered, or the reason for the trigger would be failing to meet any of the reporting deadlines, causing a reporting company to be unable to file a true and correct and complete beneficial ownership information report by withholding or providing any false information, or fraudulently reporting any false information to FinCEN. So the penalties can apply to not only the business, but to its senior officers.
That sounds pretty serious.
It
Right. Do you mind telling us about why we should be working with an attorney for CTA compliance?
Yeah, absolutely. So, obviously we've read the CTA in its entirety. We have a nuanced understanding of how it applies to different entities and ownership structures. And we've identified certain fact patterns that are likely to result in errors or failure to report required information. So if you use our firm to file your CTA report, you can rest assured that we've accurately identified whether your entity is a reporting company, whether or not it meets any of the exemptions, and who the beneficial owners are of the reporting company as well.
What other services does DBL provide to assist business owners?
Yeah, so like I said at the introduction, we're a full service law firm. So in addition to assisting our clients with their CTA compliance needs, we provide legal representation from startup through exit. If you need help forming a company, drafting or negotiating contracts, obtaining a patent or a trademark, contracting with the U.S. government, raising capital from investors, or buying or selling a business, our attorneys are ready to assist with those types of matters.
Thank you both for the very comprehensive overview of the contents of the Corporate Transparency Act. Now we can open up for questions if anyone has questions for the attorneys. You can either comment them in the chat or you can say it out loud if you'd like.
question. Are 501c6 associations subject to reporting? Trade association.
Yeah, it's yeah. So that's a good question. I haven't been asked that question yet. My understanding is it's 501c3s and then certain political 527E. So I'm not entirely sure the answer to that question. I would lean towards yes, they are. But I don't know for sure what the answer is to that question.
I had another question involving identification sources. You said you can use passports and you can use driver's license, for example, but I also understand that if there's any change in those, that would trigger reporting to FinCEN. So in the case you use your driver's license and it expires, does that trigger this need to report?
Not the not the expiration of the license itself, but if any of the information, the other information that you provided changed, then you would need to update that. So like if your address changed, something like that, then you would need to update that. You can also go get if you want, you can also get a FinCEN ID. And then you would just need to update FinCEN on that information. And so when you if you filed a report using a FinCEN ID, then what you would need to do is update the ID filing itself, not the report. So that could make things a little bit easier as well, especially if you have multiple filings.
So the FinCEN ID can be achieved online.
Yeah, it's on it's right there on the same site on FinCEN's website for the beneficial ownership information reports. If you you can create the ID first. And then you'll get the ID number immediately. And then so when you go to file your reports, you would just enter the ID number and you can skip a lot of the other information.
Now, I also understand that the regulations provide consequences if you disclose information that is supplied to FinCEN. So the question I've got is that in the case of my company, which is a small subchapter S corporation, if I were to just disclose beneficial ownership, say to my bank or insurance company, would that trigger consequences under the CTA?
I think, I'd have to look at the specific part of the statute that you're referring to. My understanding, though, would be that would only be the case that those types of penalties would only apply to third parties who would be divulging that information. So, I mean, if it's your information, obviously you can still tell your bank the information they need to transact business with you. I think if I understood your question correctly.
That's exactly it.
Yeah.
Awesome. We have 2 questions in the chat as well. Wright, would you like to take a look at the chat directly, or I could read them to you?
Yeah, I'll take a look.
So for Kristen's question, yes, this is a one-time reporting. It's not an annual thing. Really, after that, you do have to report any changes or the amendments.
Cheryl, if you could clarify a little bit more about what you're asking there, I could try to answer your question, but I'm not sure. The question's a little too broad. And do we have any other questions?
It seems to me like Cheryl's asking if there's a group that is controlling the business. So 5 entities under common ownership.
Yeah, so the way this generally works, Cheryl, is you follow the trail all the way to the ultimate beneficial owners, right? So you just keep going and going and going until you get to individuals. So you're determining it, the beneficial owners are all going to be, you're going to keep going until you get to individuals, basically. So I think the answer to your question is, it's going to be on the entity level. So unless there's unless you meet one of the exceptions. Like, for example, in this scenario, I guess, if you had subsidiaries of a parent, in that sense, then, the subsidiaries may be exempt if the parent's exempt. But otherwise, yeah, you're just going to follow it all the way to the entity level and, who's going to be, filing the report. Martin, I don't know if it's possible to mail it in rather than completing it online. I haven't looked into that. We've been doing them online for our clients. And so, I don't know for sure. I know that the portal exists and it's available, and it's really actually pretty easy to use. But I don't know for sure if there's a way to mail in your filings. I would imagine there is, but I'm not sure. If you can't obtain, yeah, go ahead, Brandon.
I would think it would be more secure to do it through their website as opposed to, since there's kind of sensitive documents, with regard to like a social security number, or your passport, or just any type of really like sensitive document. So I would think filing it online would be a better way to submit that report.
Right. I wouldn't want to mail a picture of my passport or driver's license and then have the risk of the mail not actually being delivered.
Right.
All right, we'll take one more here. What do you do if you can't obtain information from one of the partners in a small business? So, there are, basically the way that the penalties work is they would apply to anyone who essentially obstructs your ability to provide this information. We're putting clauses in any new operating agreements that we're drafting that require members to provide the beneficial ownership information, as required under CTA. But you can certainly pass along the information that if somebody's not willing to provide you the information, that you just have to let Treasury and FinCEN know that you've provided everything that you could, but that somebody's not providing that information. I would, if you let them know that they're not going to continue to withhold that information once they know what the penalties are, which are fines and possible jail time as well. Wrap it there, and if anybody has any additional questions, they can reach out to us, via email or through the website.
Right. So I'm going to be sending 2 follow-up emails to everyone. The first one's going to be today. That one will include all of the contact details for Wright and Brandon. I'm also going to send you a flyer that we have that summarizes what we talked about today, as well as a link to our website where we also describe some of this information in writing so that you didn't have to take notes if you did not do that. Also, I'll be sending an email later with a link to the video recording of this webinar, and that's just so that you can rewatch it later or share it with someone else if you'd like to do so. Thank you for attending, and I think that's everything. Thanks, guys.
Thank you.